call the special meeting of Wyomissing Borough Council to order. And with that, I'll turn it over to our borough solicitor, Mr. Hartman.
Good morning. I'm Christopher Hartman. I'm the solicitor for the Borough of Wyomissing. This morning we have a conditional use zoning hearing scheduled. And this is the place and time designated by notice to consider the application of Boiler House Island LLC for a conditional use in accordance with section 503D and section 505D of the Borough of Wyomissing zoning ordinance of 2010 as amended and the Pennsylvania Municipalities Planning Code. The application for conditional use, if approved by the Council of the Borough of Wyomissing, would allow a property measuring 1.77 acres in size to utilize the redevelopment area mixed-use incentive overlay zoning district regulations instead of complying with the required 2-acre lot size, and would allow paved coverage of 49% of the lot in excess of the maximum 10% paving permitted by right in that set of regulations. The property which is the subject of the application is located at 15 Innovation Way, Wyomissing Borough, Berks County, Pennsylvania, in the Retail Commercial District C2 and the Special Commercial District C3, and is located within the redevelopment area mixed use incentive overlay district. Before proceeding any further, I want to ask if there is anyone present who wishes to be recognized as a party to this proceeding. I see the applicant is represented, Attorney Frankowski. Do you want to enter your appearance?
Yeah, Attorney Kelsey Frankowski on behalf of the applicant, 4 Park Plaza, Suite 205, Wyomissing, PA 19610.
Thank you. At this time, I want to ask if there's anyone else present today who wishes to be recognized as a party to this matter. Party status would give you the right to call witnesses and to appeal the decision of the Borough Council. Is there anyone present who wishes to be a party in addition to the applicant? I see no indication of that, so the applicant will be the sole party in this matter. I want to inform everyone that anyone who seeks to offer evidence regarding this matter will be required to be sworn by the stenographer before testifying before council. Further, public notice of this hearing was duly advertised in the Reading Eagle newspaper on November 1, 2023 and November 8, 2023. Adjoining property owners were notified of this hearing by mailing sent on October 26, 2023. Notice of this hearing was posted on the property by Jim Babb, Public Works of the Borough of Wyomissing on October 25, 2023. At this time, council offers the following exhibits to be made part of the record. Exhibit 1 would be the application of Boiler House Island LLC requesting a conditional use to allow paved coverage in excess of the maximum 10% permitted by right. And that application includes an engineer analysis that was submitted by the applicant. Exhibit 2 would be the site plan dated October 14, 2023. Exhibit 3 is an email from the applicant dated October 17, 2023, amending the application to include the request for adjustment of the lot size requirement. Exhibit 4 is an October 25 email from the applicant, including with the application reference to section 505D of the zoning ordinance. Exhibit 5 is a letter by the commercial zoning officer dated October 24, 2023, providing comments on the conditional use application. Exhibit 6 is a letter by the from the commercial zoning officer dated November 14, 2023, providing comments on the conditional use application. Exhibit 7 is a notice of today's hearing Exhibit 8 is the proof of publication of the notice in the Reading Eagle, which I don't believe we've received yet, but we have received, okay. And Exhibit 9 is the affidavit of service by mail of those folks who received service by mail. Exhibit 10 is the affidavit of the posting of the notice on the property. And Exhibit 11 would be the zoning ordinance of the Borough of Wyomissing as amended. Is there any objection to the inclusion of those exhibits in the record?
I have no objection.
All right, thank you very much. With that, those exhibits will be part of the record of today's hearing. And before the applicant begins to present testimony, I just want to make the council and the rest of the audience today aware of what the standard is that the Borough Council is going to be applying in reviewing the evidence that's presented today. Under section 505D of the Borough of Wyomissing zoning ordinance, the dimensional regulations that are at issue here, the lot size and the maximum paved cover on the lot, are regulations which may be modified upon application and approval of a conditional use by the Borough Council. The standard for approval of the conditional use shall be substantial evidence that the property can be developed in accordance with the literal requirements of section 503D and 504D. Those are the sections which include those dimensional regulations I mentioned. Due to topographic features of the property, stormwater-related characteristics of the site, lot size, lot shape, proximity to a street intersection, and safe site distance requirements. A written report including an engineering analysis of such substantial evidence shall be submitted with the conditional use application. So that is the standard that council should be keeping in mind as you listen to the testimony this morning. With that, I'm going to turn to Attorney Frankowski and ask her to present her case.
Yes, the first witness I'm going to call is Greg Boja.
Greg, would you allow yourself to be sworn?
Is it true, do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Boja, can you just state your name and address for the record?
Sure. Greg Boja, work address for Boja Engineering, 1340 Penn Ave, Wyomissing, PA, 19612.
And I think most of council knows Mr. Boja. I was going to move to have him qualified as an expert witness in professional engineering. I do have his CV that I can present as an exhibit if council would require that.
I would recommend to council that Greg be accepted as an expert witness in engineering.
In professional engineering.
Professional engineering. Is that acceptable to council?
Well, what part is professional, I mean, is it civil engineers, electrical,
Civil, traffic, land.
thank you.
Thanks for that qualification. All right, so council accepts Mr. Boja as an expert witness in professional engineering related to civil, traffic, and what was the third category? Land planning? Okay, very good.
Thank you. Mr. Boja, are you familiar with the applicant, in this case, Boiler House Island LLC?
Yes,
And did the applicant engage you to prepare plans for a proposed development at 15 Innovation Way in the Borough of Wyomissing?
yes,
And are you familiar with where that particular piece of property is located?
yes.
And I'd asked Michelle, I did send in some exhibits. Do you have the parcel map, the tax parcel map? I think it was A1.
Those were all for the zoning board, but I can get them.
That's fine. If not, we can just pull up the plans. Give me one second.
There's, should be a second up one.
Yeah, I just wanted to give council an idea of where this was located and what it looked like. Is the property outlined in red on applicant's exhibit 1, the property that you were engaged to prepare site plans for?
Yes,
And is that an accurate depiction of where the property is located in the borough and what it currently looks like?
Yes,
And this exhibit shows the property to be vacant. To your knowledge, is the property currently vacant?
the property is currently vacant.
And to your knowledge, the applicant does own this property.
Yes,
And you drew up plans for the proposed development for the applicant?
yes,
And I'll ask you to take a look at, it would be applicants too, but it is the borough's exhibit 2 as well. Are those the plans that you drew up for the applicant?
yes.
I'd like you just to go through the plans for council and tell them exactly what is proposed on the site. You can use the laser pointer.
The apartment building's located right here. This is North Park Road. This was the existing bank building that was changed over recently, to where I think they house cars. And then back through here off Innovation Way is the Drexel Training Hospital. So here is the proposed access. Early on in the process, we had looked for main accesses off of North Park. That wasn't something I think the borough was really interested in, so it's something that was discontinued. I would say that we're probably not gonna be looking for any type of access unless emergency services from the borough would request it in some way. Other than that, there's parking shown here on the south side with the building, likely in garages, and then the rest of the parking fields here. You can see how it's a regularly shaped lot with kind of the L shape that's there that we have to work with. It was, I did just want to bring the note, it's already been subdivided previously, so it's not that this lot was created this way, it was already the 1.77 acres when the applicant had purchased the property. Also, I should note, this is the Norfolk Southern line through here.
And the use of apartment buildings itself is a permitted use by right in this district?
Yes,
Okay. And the applicant did require a variance for an issue related to the parking area on this site, is that accurate?
correct,
And that variance was granted by the Borough Zoning Hearing Board?
yes.
Can you explain to the council what conditional use approval the applicant needs with respect to the lot size and the paved area requirements?
The paved area requirements was 10%. This lot has approximately 49%. So that was the conditional use request. And also the list out of the 505D for the topographic features is.
Are you going through your analysis right now?
Sure.
Okay,
Go
so, if you could just take council through the engineering analysis that you prepared as part of the conditional use application, which is required by 505D of the borough ordinance.
Sure. The property currently has a 16-foot high topsoil mound that's over the bulk of the property, say where the hotel would be, or the apartments would be located. For the stormwater management, the stormwater gets collected around the topsoil pile, and then it basically goes in through the pipes to the Pennsylvania Line Railroad tracks, Norfolk Southern, to the south. So this project would go ahead and install additional inlets and stormwater control once the topsoil mound is eliminated. The lot size, as I discussed earlier, is already 1.77 acres from a previous subdivision, and requires, because of its size being less than 2 acres, requires the need for the conditional use. Again, the lot shape is the L shape that we spoke about, where it mentions where it's 108 feet and also 155 feet, depending on the measurements of the L. The part that's unique with this is the overall design is really not to have access out to North Park Road, but to go ahead and have access off of Innovation Way. And It's at the end of Innovation Way, and there is no real need for site distance because it's at the end of the road, at that location. At the end of the drive.
And can you explain why the property can't be developed in accordance with the literal requirements of 503D with respect to lot size and paved area requirements with respect to the conditions that you just kind of went through?
Sure. Mainly, it's already been subdivided, which is how it got created. It already has the Norfolk Southern lines to the south. It has the other commercial use to the north, and also to the east and to the west is North Park Road.
So in your expert opinion, due to the topographic features of the property contained in your engineering analysis, the property can't be developed in accordance with the literal requirements of 503D and conditional use would be required.
Correct.
I have nothing further for this witness.
Thank you. I have one follow-up question at this time, and that is regarding the access. Does the property owner have a right of access to use Innovation Way or to get to an Innovation Way and then to travel on Innovation Way? Because that is a private road. So anyway, can you walk us through the access rights that attach to this property?
Yeah, part of the purchase of the property required that an easement be recorded for the use of Innovation Way to be able to access this parcel.
And is that already recorded or is that yet to be recorded?
I believe it's already recorded.
Does council have any questions for Mr. Bosher about his testimony this morning?
I just have one, and I guess this is more directed at Mr. McCarthy. When Innovation Way was constructed, can it handle this additional traffic?
Right, if, we're gonna jump around a little bit. Attorney Frankowski, are you okay if I have Jim sworn and we let him?
Yeah, I have no objection.
All right. Mr. McCarthy, would you be willing to be sworn?
Yes. James C. McCarthy, 1011 North Park Road, Suite 100, Wyomissing, 11610.
Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. McCarthy, do you have a position here with the Borough Government?
Yes,
And
I'm
what is that position?
the Wyomissing Borough Engineer.
Thank you. What is your question?
When Innovation Way was constructed, can the road handle that much additional traffic?
There was no, when the Equus project came through and Innovation Way was looked at and all those other things for the study and looking at the PennDOT HOP, there was no additional development on this track proposed at that time. As far as doesn't handle it, wouldn't know that today without looking at it further.
Mr. McCarthy, would it be part of a land development planning process for this project to evaluate the conditions of access and the roadway?
Yes.
And would you recommend as a condition of any approval that might be granted by council this morning that the applicant be required to go through the normal land development planning process, including reviewing the access conditions?
Yes, that should all be required. It's just an advance right there.
Are there any other questions for Mr. McCarthy?
Are there any factors that would bring in the railroad as far as Norfolk?
I'm sorry, could you speak up a little bit?
Are there any factors with regard to the development that would impact Norfolk Southern and vice versa with regard to the use of the property?
Yeah, that's a good question. When we looked at it, we recognized that Norfolk Southern really doesn't like to have any new point of discharge occur onto their property. So the design is to go ahead and use the existing pipes that already cross those property lines.
So is your answer, Mr. Bosher, that the impact relating to the railroad is really stormwater, and you have a stormwater plan that will avoid additional discharge onto the railroad?
Correct.
Just have one follow-up question. With regard to the occupancy, it's apartments, correct?
Correct.
Is there any impact to Norfolk Southern's use of the rail lines there and impacting the ability to actually create a living space for apartments? Because those trains, I don't know how many go by there every day, but if they're the same ones that go down.
No, that's a main Norfolk Southern rail line. They probably range from about 25 to 40 trains a day at that location, so it's quite common. And there is no prohibitions about having apartments at that location from Norfolk Southern.
So I guess there's no prohibition against people having trains running past their apartment every day.
Correct.
Shouldn't be a factor.
No, I think like all of us, we kind of get used to things as they occur, and after a while, you hardly notice things like that.
I'm not sure what relevance the 16 feet of topsoil has to what you request, but since you bring it up in your report, do you have any understanding of why that's there? Yeah, I mean,
If you want to go ahead.
Is it covering up contamination?
I have been mentioned or told from the borough side that might be a case. I don't know it as a fact one way or the other myself because I haven't seen any test results or anything like that. I recognize that in Mr. McCarthy's letter that was something that he would like to have go through as part of the land development process. So, you know, I expect it to be a continued discussion between my client because I did the civil and the traffic type work. I don't do the environmental soils type work, which is the question you have. So there is a mound there. It was placed there, I would presume, from when there was other development that had occurred further to the east on the lots. And this was the place where it was deposited. So it definitely changes the stormwater, which is why it's brought up with what I wrote down. And we're gonna change that to remove it so that we could build the apartments.
So people don't blow in the door?
I couldn't hear you.
So people don't blow in the door?
Correct, that's something none of us wanna be involved in.
That's a plus for the residents, yes.
Mr. Bojek, with your plan at whatever stage of progress it is right now, where is that soil planned to go? Is it intended to be removed from the site, or is it intended to be moved within the site?
I believe it's intended to be placed at the property between the rail lines.
Okay.
And that's the intention, I can't say for factual, but that's the intention.
Okay. So that, who owns that property?
The applicant.
Okay, so it's the same owner, a different
Yes.
property?
Correct.
I understand. Are there any other questions from council? Okay, I want to ask our commercial zoning officer, our borough engineer, and our borough manager if they have any questions for the applicant. No? Is there any information that any of you want to have included in the record in addition to what Mr. McCarthy has already testified to?
I believe the letter covers anything else we would have additional.
Okay, so your review letters speak for themselves?
Yes.
Okay.
Can I ask one more question?
Go ahead.
With regard to the Norfolk Southern issue, I've had experience with Norfolk Southern. They're not the easiest people to work with. Is this a situation where you have to get past Norfolk Southern to get to this point? Or if we do this, we're going to be faced with a large problem with Norfolk Southern? It seems like it's sort of an issue that hasn't really been touched yet.
I don't believe that we need any Norfolk Southern permission to move forward.
I'm sorry.
I don't see that there's any need for Norfolk Southern permission to move forward, because there's no change.
From a legal perspective, they haven't required anything, so.
I want to ask again our commercial zoning officer, borough engineer, and borough manager, are there any conditions that you are recommending, or do you want to discuss that? Okay, we have a question. Go
What are
ahead.
they doing with the existing, the old power plant itself? Do you plan on using that or tearing that down?
I think there's probably been discussions both ways. I don't think that's been set, and that's why that application is probably lagging. I would anticipate that coming before the board at some point in the future, but I don't know that there's been a defined type use at this point. So that's still in like the cognitive stage where it's a thought process and it's not yet determined what the owner would like to do. Sure.
As a follow-up to that question, has there been any inspection of that property to determine whether or not what you think may be under the big mound might also be in the big building that would impact the ability to carry through on this project because of the sheer cost of removing all of this, whatever may be there?
I'm not certain of what might exist at either location. It's the best answer to that question. To try to answer your question, that typically most applicants would probably like to be able to move the soil to a defined location that works well for them, and that's not overly expensive from other projects where I've done the engineering. I'm not involved in the environmental side, but where I just look at that as more fill, and it gets treated that way, and you know, there are maybe some precautions for the workers while they do it for dust. That's what would be done, I suppose, by this owner as well, if there is found to be contaminants, you know, on that parcel. That discussion today.
You've not spoken about the lot coverage. Is there anything you wanted to say or just to read?
The lot coverage, for me, I look at it that it's always good to have your parking adjacent to the buildings you're doing. So, you know, that's why you see it tight to the building. Parking's needed to meet the other ordinances. So for me to put everything together and be compliant with many of the other ordinances, that's what made sense to have on the plan and to come ask for the relief.
Mayor has a few questions.
Yeah, I don't have any concern about it, but Attorney Frankowski, do you have any objection if the mayor jumps in and asks a question?
I have no objection.
Okay. Mr. Mayor?
Does the parking field for the proposed apartments adequately provide access over that existing bridge to the 9-acre island, which is potentially subject to further development?
Sure. If you want to bring up the drawing. Here's the bridge that crosses, and when the applicant had purchased the property, he was provided the engineering documents of the inspection, and the bridge was actually in pretty good shape through here. So we left the opening that's there to continue through. And for his use, he had the rights from the documents that were provided through here, and he can make his connection that way as well.
So the existing bridge probably, in my opinion, need to be enlarged if you're going to adequately develop what is about a 9-acre parcel there, is what we call the island. So could be a lot of vehicles.
I think that discussion would probably be best had when the use of that island would come forward.
Yeah, I don't think the applicant or the owner of that parcel knows what is going to happen or be developed on that
Now,
parcel
I
yet.
understand that, but potentially it could be, I just want to make sure that the parking lot is adequate and it could be impacted, reduced in size or something, if there's something intensive done on the island.
Yeah, I guess with the project the way it was laid out for us, for this site, we left it open. Now, how, you know, others did their parking lot that's outside of the site that already exists is outside of our control. So we laid it out the best for access that we could with what we've had to work with and the existing conditions that we were handling.
I think the mayor's question is really, is the proposed development of this site going to inhibit the potential redevelopment of the other property that your client owns?
No, that would not occur.
Is that what you're getting at?
Accept Greg's opinion, not that I entirely agree with it.
Okay. Any other questions from anyone? Mr. J, we're gonna give you a public comment opportunity later, but you're not a party. We're not gonna let you
Fair enough,
jump in right
I was
now.
just making a sign.
Very good. Again, I wanna ask about potential conditions on this. Is that something you wanna share with us now, or we could do that as part of a executive session, if council wants to have an executive session on this matter. But I want to be careful that, you know, any conditions that we might discuss should be based on testimony. And if we have some conditions in mind that are not related to testimony already received, we should get that in the record now. Is there anything like that?
Well, I think if you look at our letter of yesterday, we do have some recommendations, conditions on, to start on page 1, and continue on page 2, there's 9 of them. You know, a revised land development plan including stormwater shall be reviewed and approved by the borough.
Excuse me. You just let know.
Okay, they're 1 through 9 on exhibit A. What exhibit is this?
Okay, that is exhibit 6.
So there are items on exhibit 6 under A, items 1 through 9. Probably easier, right?
Okay, that's great.
If I can,
Yes.
I can provide the board the approved ENS and MPDS permits that have already been obtained.
For then, Hal, you didn't get us do a stormwater review.
We've had the opportunity to continue work on the project.
Well,
That's for a different layout, isn't it? Prior submission?
I would hesitate to include this in the record, Greg, because, again, we haven't gotten through the land development planning process, and I wanna make sure that our engineer is satisfied that this is applicable to the project at hand. So I would prefer that we would go with the general conditions regarding stormwater planning, rather than to rely on the permit that you've already got.
That's fine.
I'd agree, let's not include these in the record or as exhibits.
So, Mr. Boscia, Attorney Frankowski, you received copies of the November 14th letter from McCarthy Engineering, which is an exhibit in this matter. Jim has referred to proposed 9 conditions. Is there anything that you find troubling with those recommended conditions?
The only item that I had was for number 9, that we're fine to not have access to North Park Road unless, as we would go through the fire side, that they would like to have some sort of access. Other than that, we're perfectly fine to not have access to North Park Road.
All right.
And I have no issue with any of the other 9 recommendations or conditions.
I'm not sure it's even attractive as an emergency access because of its proximity to the bridge. Do you have an opinion on that, Jim?
So PennDOT reached out when they made the initial submission to our office, actually to Michelle, and then she directed them to our office about the access, that they didn't think any access along this frontage was safe coming over the bridge. We have shared the same opinion, and so did the traffic planning and design, the borough's traffic consultant. So then PennDOT sent a letter saying they wouldn't issue a permit along the frontage. So I don't believe
Now, would that-
PennDOT's going to issue a permit in that location.
Okay. Would that PennDOT permitting process be required for an emergency access?
Yes.
All right. If that condition is included in any decision that council might make, will you accept that or not? Or will you object to it, is, I guess, my question.
Generally, we'd like to be able just to work it out that it's not needed.
Yeah, I mean, if PennDOT won't allow it anyway, and
Okay.
then,
Well, I think what makes sense to me is I would recommend to council, if council chooses to approve the application that's pending, that condition be included. And if for some reason, somewhere down the road, there's a reason to revisit that, there's always a possibility of doing that. But I think it makes most sense to include that condition at this time. Anyway, that's my recommendation. All right, thank you. Anything else, Jim?
Just the one thing I really didn't cover was our last comment 8 on page 3 under general. They say they can't add any area to this to get to 2 acres, yet they only adjoining 9 acres. I didn't hear anybody say anything to why can't that or a portion of that be added to meet the requirements of the ordinance.
Okay, is all of that adjoining land on the other side of the railroad?
yes.
Yes.
Okay, so all of the land that is on the same side of the railroad is included in this 1.77 acre lot, is that correct?
Correct.
All right. Jim has a valid point, but can you provide a response to that comment from McCarthy?
And it would further reduce the paved coverage requirement if
Correct.
we were.
I mean, both of the conditional use requests could be eliminated if there were land added to this lot from the other lot owned by the same applicant across the road. So tell us your position on that.
The reason I looked at it and didn't consider that that was to occur was that the Norfolk Southern Rail Line already bifurcated the properties, so they would be 2 distinct properties. There was an easement for the bridge that went over Norfolk Southern's property, so it wasn't actual real property for a connection. So with that, because it wasn't physically connected, that the borough, and from what I've seen, is the borough had approved the 1.77 recently to be subdivided off. So it appeared to me that the borough would also have liked maybe at that time for it to be subdivided, so it didn't make sense to go back and try to doing something that was across the railroad that really didn't have any physical connections itself, because it's not like there was an underlying ownership under the railroad to make that connection either. So that's why I didn't think it made sense to have that connection.
So, I'm confused by a statement there, because this subdivision plan never went before the borough's planning commission or council that we're aware of. I mean, when Equus came through with the land development plan for the medical
Let's have you
school.
sworn.
I'm thinking I swore you.
Yeah, I would like the borough manager, Michelle Bear, to be sworn.
Do you swear the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
What's your name?
Michelle Elaine Bear,
And by whom are you employed?
the borough of
In
Wyomissing.
what position?
I'm the borough manager.
All right, and you're familiar with this project?
I am.
Based on all of your experiences here at the borough?
Yes.
All right, please continue.
When Equus came in with the land development plan for the Drexel University College of Medicine, at that time and up until my understanding, whenever this deed was recorded that the property transferred, this was one singular parcel. I don't know when this subdivision plan went through, but I have the chair of the planning commission sitting here. I think he would agree that we've not reviewed it, so
Would you be kind enough just to pull up the Berks County parcel viewer so that
I'm not disagreeing that it's a it's on the parcel map, but
I'm just trying to work with what we were handed.
Yeah, the applicant didn't subdivide the property, he bought the applicant bought the parcels after whatever subdivision had occurred, so we don't really have information.
Well, Mr. Bosch, I think you would agree with me that the assessment office makes up lots how it chooses, and it is not necessarily related to any land development or subdivision process in many cases.
I understand some things can happen, and we're just trying to work with what we were provided.
I mean, clearly it's, no,
Good too.
it's two, it's got two.
Yeah.
It's got two.
But it also shows that it would be simple to the north side of the railway.
Yeah, I mean, what
Yeah.
the assessment office shows on these maps,
Isn't
to me,
correct.
is not persuasive of what the status of the land is with regard to, the existence of lots.
Could you check out see if they're the same parcel numbers?
They're not, that's what I was looking at.
They're separate.
That's the way I saw it too. So that led me to think that everything had been subdivided by the prior owner.
No, our understanding was everything was condoed. There was a condo declaration recorded, but
But not something.
not a subdivision plan.
Okay, well, if it were a condo lot, it is a unit of real estate, not a subdivided lot, but it is still a unit of real estate. So, I mean, we can, for practical purposes, treat it as a lot. But the basic situation exists that the applicant owns other land, whether it's adjacent or nearby. So the question for council is whether or not that makes a difference in your consideration of the relief that's being sought today.
How would they ever develop that tract of land that's closest to that property? It would be impossible. Setbacks, that would be,
Are you talking about this tract?
yes.
I disagree, because it's 9 acres.
No, I know that, but how would you shape it? It only needs what, a couple, like a half acre, third acre to make the minimum. So,
Oh, you mean to subdivide off of this to
Yes.
annex onto that?
right,
Yeah.
what do you do with that extra third of an acre? You can't develop anything.
Yeah, it would be, I agree.
It would be,
But,
So we could achieve technical compliance, but it's not really useful.
right, and it's not contiguous, it
Well,
makes sense.
It's contiguous over the bridge, I guess, right? But that doesn't help you.
Well, the bridge is in real estate, I think,
Yeah.
and the assessment office is
Right.
making up facts by showing that as okay. Thank you for all of those comments. Are there any other comments that you want to offer?
no.
Art? Well, that's, I mean, subdivision, I guess we can review that. I don't think it is. I mean, I'm considering it, if it's a condo unit, I'm satisfied that it's a unit of real estate. But we can give further evaluation of that because we don't have a title report or other information here to fully evaluate that. But I think as part of the land development planning process, we could look further into that particular aspect of the development of property.
So you don't think it needs to be a condition?
I don't think
We
we
don't
have
need
enough.
that one, Jason.
We could add a condition that there should be an investigation during the land development planning process of the status of the property as a separate lot. You know, so that, we can just defer that, but include it as a requirement that that issue be evaluated. Yes, sir.
I have one more question. How many apartments?
It was 54.
54.
How much?
54.
54.
Chris, I have another question.
Yes.
I'd like to go back to what the mayor mentioned and what became a conversation that seems to went right past me, but with the issue of PennDOT and the approvals regarding the emergency access, that if they don't grant that, is that going to prohibit the ability to follow the project? Or is there some other way to get out of there if PennDOT says no way, Jose?
Generally, we try to make it easier for the fire or emergency personnel to access sites as they please. We recognize that there's curbs, that the vehicles are made to go over the curbs. Typically, most try not to during those situations. So we try to provide a paved surface for them to do that. The main access for Innovation Way is at the traffic signal. That's located just a little further along on North Park Road. So the vehicles could come down through Innovation Way and come through that way, where they would continue down. The second way would be through Innovation Way and a little further to the east and come down through that other parking lot, which is the mayor kind of picked up that it's not necessarily a straight shot from the way the parking lot was laid out on the adjacent site. So assuming that's acceptable to the Wyomissing Fire and Borough Department as we go through the process, I believe that would also be fine with the applicant, or that they would recognize they could go over the curve on North Park Road. But if they dug in and saw something different, that's why I was trying to leave a window open so that we could come back and address it later if that became their stance. Just because we haven't gone through that yet in land development.
So at the end of the day, there is a way to make this happen if the state says no way.
Yes.
Sir, where is the proposed driveway in comparison to the base of Park Road Bridge? I mean, what distance are we talking?
Less than 100 feet, I think it was. So the Park Road Bridge is right here. That's the bridge.
Less than 100 feet?
And the proposed access drive was roughly in here.
If I can.
You're not gonna get an aerial to make that radius.
No.
Well, the bigger concern was line of sight coming over the bridge.
Right,
If you have that
exactly.
driveway.
Yeah.
The line of sight only worked for like a right in. So, you weren't gonna get anything out. The applicant's not pushing to have regular access at that location. So we're really just trying to make sure we can take care of the emergency services group.
It's the same situation with the former bank. Already there.
All right, are there any other questions? If not, I'm going to recommend that we close the record and, let me see, how do we have that on? Okay. I'm still gonna recommend we close the record and accept the exhibits. Is that acceptable to council?
Yes.
All right, thank you. Now we're gonna have public comment. Mr. Jade,
How do you want me to do it, as questions or a comment?
you are entitled to only make comment. You're not entitled to ask questions.
Fair enough. So my concern here is, I've heard Mr. Boja say several times in his testimony that that is a pile of topsoil. Then, further upon discussion, he said that he doesn't know what's there. So we don't know, as an expert witness, I would have hoped that you can provide us, is that a ½ inch of topsoil? Is it topsoil at all? Is it 2 feet of topsoil? What is it? Because then we cannot claim, and as an expert witness, that is topsoil. So that's my first concern. The second is about transparency. Transparency of, again, environmentally. When we ask, come for a conditional hearing, I think the public needs to know when we start excavating, what is there? We need to do some core samples, we need to do, to know, and the public needs to know, because if they bring the excavators and let's assume, which could be very possible, that underneath that might be asbestos. Once they start digging, asbestos becomes airborne, too late. So I think from the point of view of transparency to the public, I think we need to have this before anything is approved. We need to know, once we start digging, removing that stuff. And just like Jana said, maybe there is some glowing stuff there. So, and I think also the people who might rent these apartments are entitled to know what are they sitting on. So, again, this is about transparency, and I would have loved to see this clarified here, not, oh, we don't know, but we want to start digging.
Thank you,
So,
Mr. Jade.
Thank you.
For the sake of transparency, I want to make you aware, because you might not be familiar with what conditions Mr. McCarthy's firm had already recommended. One of those conditions is that the applicant shall test the site for contaminants. Based on the findings, the applicant shall provide a plan to remove the topsoil mound compliant with all state, local, and federal regulations. So we are addressing the subject matter that you referred to in your
But it's about transparency to the public. Will that happen? Will we know what it was there, what was there? That was my comment about it.
Okay.
Okay?
Does that also apply to the building? You said that you were talking about the amount of dirt, but that also apply to the building?
No, that's a separate parcel, that's not the subject.
Well, are you talking about the building on the other side of the railroad?
No, the building, the existing power plant, the old power plant.
Okay, that is not part of this project. So if and when there is a proposal, see, we're only, what we're talking about today is only on the north side of the railroad. The island, so-called island between the railroad tracks is not part of today's project. That is a potential project in the future, but it is not for today. The only thing at stake today is north of the railroad, next to the old bank.
Okay, so it does not include the existing old power plant? Okay, it's west of that. Okay.
North.
North of,
Yeah.
yes, west.
Okay, with that, I'm gonna offer to council, the opportunity, if it chooses, to have an executive session to talk about any legal questions council might have about, what has occurred this morning. If not, I'll just make a recommendation to you now. What do you want to do?
What's the pleasure of council? I'm sorry.
I don't need anything. They need it.
No.
Okay, I'm gonna recommend to council that you consider a motion to approve the application subject to 10 conditions, being the 9 conditions listed on page 1 and 2 of the November 14, 2023 McCarthy Engineering letter, plus a requirement that as part of the land development planning process for the project, the status of the parcel as an existing lot shall be evaluated. Jim, something else?
I think you missed one. There was one made, said it was gonna be, was they provide proof that the easement allows access from Innovation
Oh, yeah,
Way
thank you.
for the parcel.
I think
So
that's
that would
already
be-
in the 9 conditions.
Condition,
That's already in the letter.
That he was provided.
And then the other one would be stormwater discharge from North Oak Southern.
stormwater discharge,
Approval of stormwater discharge to North Oak Southern right away.
okay, that's not among your conditions here?
No.
Okay. Or can we say, approval of stormwater discharge from Norfolk Southern if required, or are you confident that it is required?
No confidence required, but you can put it required.
If required, okay.
I put the wording of 10, I don't, just how you
Excuse me,
said,
we need to speak up.
I'm questioning the wording of number 10. to me, simply investigating is not enough. It seems to me that somebody ought to determine whether something needs to be done.
Okay.
And if so, then it is done.
Are we talking about contamination?
Okay, that the status of the parcel as an existing lot shall be evaluated and, based on the conclusion of that evaluation, appropriate follow-up will be required. Are you satisfied with that? It's-
That's much better, thank you.
Okay.
I'll make that motion.
We seconded it, I'm sorry.
Mr. Spango?
Did you get that all down, Melissa?
Okay,
We'll be done.
with that, has there been,
Oh, yeah. We have a motion and a second. All those in favor? Aye. Opposed? The ayes have it.
okay, thank you. That, I believe, concludes our business. The Borough Council will issue a written decision within 45 days based on the outcome that has just occurred. If the applicant is dissatisfied with the decision, the applicant has the right to appeal the decision to the Court of Common Pleas within 30 days after receipt of the written decision. Are there any questions? If not, I think that concludes. We can,
Entertain a motion to adjourn?
So moved.
Thank you.
Thank you.
Motion second, we are adjourned. Thank you.